we are going to keep it completely practical. Let us assume that Corona is over and your defense counsels are landing up in the court tomorrow morning, and Mr. Prosecutor has lined up his prosecution witness and you are supposed to cross-examine. Or maybe in a complaint case, you are defending the husband, and in a 498A case, the wife's witness is being recorded. Maybe in a complaint case or in a domestic violence act case or any other complaint case for that matter. What is the job of a defense counsel? There are a lot of books on cross-examination, a lot of material available, but this particular branch of strategy has not got any attention ever. And I believe that more than the lawyers, clients are responsible that this branch is not much heard of, because they would say that why to pay the appearance fee, why to give peshi of the Vakil Saab, because only the chief is to be recorded. The chief will be recorded, we will take time. That, okay, Vakil Saab is going to come and cross-examine on the next date. So, why to appear on this date? Send some intern or associate. But people do not realize that in the game of cricket, when the prosecution bats or the complaining counsel bats with their witness, you are John T. Rod's Mr. Defense Counsel. Or I would say you are Dhoni at the back doing the wicket keeping. You are supposed to stump. You are supposed to catch. You are supposed to appeal. How's that? Every time. So this particular branch has been ignored. And even the counsels being very busy, they say that, oh, today will not go in this case because only the chief is to be recorded. Now I'm going to list down the functions of the defense counsel while the chief is being recorded. First of all, defense counsel has to understand that when the prosecutor is performing with his witness, over a period, the witness has come first time to the court. For him, it is new. Over a period, the prosecutor will be asking him questions, will be making him depose against your client, and they will start getting a little comfortable with each other. You have to jump in between and break that rhythm. I give exact pointed examples now, along with the case law and the sections. You have to be on the watch, catches win matches. First, let us list the objections that you will raise. And people are ignoring you, the witness is ignoring you, prosecutor is ignoring you. No, jump it between and make your presence felt. First objection, the first mistake that a prosecutor does is that he may ask him a leading question. So, leading question 141 and 142, Evidence Act. So, he cannot ask him a question where the answer can be yes or no. So, he cannot point out towards your client and tell the witness, did you see him at the spot? So the answer would come in yes or no. And it is human tendency. The way prosecutor has his own aura in the court is giving him respect, calling him PP Saab, PP Saab. and the accused is in the dock. So, with the personality, a smart prosecutor will not give a chance to the witness to think. He will ask the question and witness would say yes, 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 yes. So you have to step in immediately and you have to be quick. The moment prosecutor asks and before the witness replies, you have to butt in between, because if the witness ends up replying later on, even if you object, even if a prosecutor asks it in a different fashion, the answer will remain the same. Immediately you will say, "Bibi Saab," leading question. You'll tell the court, "My lords," leading question. First of all, the prosecutor rhythm gets broken. The court would tell the prosecutor that no, reframe the question. During that period, you start taking over. You start stealing the show of the prosecutor. Witness will not ignore you. He will become conscious of your presence. Couple of times you can jump in and break the rhythm if the prosecutor uses an incorrect language or an incorrect language is being dictated. You can chip in between and have the language corrected. For leading question, you should remember the judgment. Though there are number of judgments on this, this Varki judgment is important. And you must prepare a judgment set of 4-5 judgments. So carry them to the court when this examination in chief is being recorded, so that the moment you object, you can flaunt the judgment also. And the prosecutor would say, yes, 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 I am aware. Okay, I am rephrasing my question. So that would show your preparation to the court also, and the court will take you seriously. Second kind of objection is going to be that the prosecutor may be showing him a document and asking him that, please tell me, Mr. Witness, when Peter wrote this document in front of you, what did he write in this third para? Witness would just read the third para and prosecutor would dictate that when Peter wrote this letter in front of this witness, Peter wrote this third para in the letter. No. You are there to appeal. You are there to stump. You are there to catch. You would say, my lord, please read section 136 Evidence Act, second paragraph. A question cannot be asked as a fact if it is dependent upon the proof of some other fact. That fact is to be proved first. First of all, ask this witness, does he recognize this letter? Then ask the witness, did he see Peter writing this letter? Then ask this question, third question. So, in 95% of the cases, witness would show his ignorance that, oh, no, this letter was not written in front of me. I saw the letter later, or I do not recognize the letter. Or then during this hoopla, you will be able to read the body language of the witness, and you would know that witness can be told to say in the court that, my lord, he seems to have seen the document first time in the court. So the witness would say that, oh, I have seen the document first time in the court. So the whole castle that prosecutor is building against you comes crumbling down. This 136 is very important. At times, the prosecutor is asking an irrelevant fact. There is some aspect on which the charges are not framed. Still, he is asking those questions. Maybe he is asking something beyond the period of conspiracy. Again, you would object to 136. But these objections the court may not accept so many times. But you have done your job. You have broken this concept of the prosecutor getting away with whatever he is asking. Next is Section 60 Evidence Act, hearsay. It is not a matter of argument at the end. You must carry this Kalyan Kumar Gogoi judgment. And if the witness is asking something in the nature of hearsay, and please be clear, this is the only judgment which says that hearsay can be in respect of oral testimony as well as documentary testimony. Documentary evidence also can be claimed to be hearsay. So, immediately object that, my lord, what is prosecutor asking? I don't know what kind of a prosecution is being conducted. Why the hearsay evidence is being recorded? And if the prosecutor says, oh my lord, this is a matter of argument, this we will argue later, and will say, no, my lords, when the evidence is being recorded in the court, I am as much as a part of this fountain of justice as the prosecutor is. My lord is here. I am here. Mr. Prosecutor is here. So it is reflecting poorly on all of us. Tomorrow, if it would go to the appellate court, and I'm sure my client is getting benefited, if prosecution would file an appeal, what would appellate court think? That what kind of evidence was being recorded in the court below? Believe me, your objection will be accepted. Again, the witness will look at you. Witness will be conscious of your presence, and prosecution would not be able to steal the march over you. The next is this aspect of hostile witness. More often than not, the prosecution commits the mistake about 154 Evidence Act. If they want to ask a question from their witness, they have to seek the permission of the court. And the prosecutor would say, oh, my lords, I am declaring this witness hostile. There is nothing of that sort. There are judgments after judgments, but it has become more conventional. Prosecutor would say, my lord, I am declaring my witness hostile. Then the court would ask him that, okay, you are giving this statement without any pressure or coercion, and then the prosecutor would start asking him the leading questions. Object that, my lord, what is this being declared hostile? Simply the prosecutor should seek the permission and start asking the questions. And then during that period, if your presence in the court, you would know the body language of the witness. At times it so happens that witness is saying something and a smart prosecutor is getting recorded something else. At times there is a general language barrier or a communication gap, that the words exactly being recorded are not conveying the same meaning. So if you feel so, then you can insist that, my lord, if witness has said something Hindi, Punjabi, Urdu, and that conveys a better meaning. In bracket after your English translation, please record the exact words. So exact meaning can be conveyed. So these kind of aberrations, interventions by you would, again, the purpose is that you do not have to permit the prosecutor and the prosecution witness to get cozy with each other. Both of them have to be conscious of your presence. Then, most common error that I have seen, and over a period, this is my favorite objections, and in Cole's camp when I appeared in the court of Mr. Bharat Parashar, before I am about to raise this objection, he would say, Vijay ji, आपकी काली राम वाली objection लिखा दे. So I have become predictable because this is my favorite objection. But prosecution is not learning. Prosecution is making this mistake again and again, feeling that it can get away with it. These days, in CBI cases or ED cases or SFIO cases, generally say economic offences in cases, the trend is that they make a person write whatever they want him to write, and they take a letter explaining the whole aspect rather than bothering to record a statement, and they take it on record. Suppose they are supposed to they ask 5 questions from a witness and ask him to give 10 documents. So the witness in a letter is replying to those 5 questions also, and there is a trend of sending questionnaires now to the witnesses. So, and he is giving the documents also, and like a covering letter, the prosecutor would seek to exhibit that letter. Then she would say, my lord, I have Kali 162 CRPC, that a statement to be police is not to be signed. So this document, otherwise what is the need for recording 161 CRPC statements at all? They can take whatever is they've taken from the witness in writing, and then they can come and exhibit. Why are they calling even the witness? The IU can come and say that I've recorded this is the handwriting of a witness, and then you prove it otherwise through some handwriting expert or something by his admitted signature. So why are you calling the witness to the court? So this kind of a statement cannot be recorded. So carry Kali Ram with you. Look at the documents. If you studied the documents with the charge sheet, you know that this particular witness is the author of this document, and this witness is going to come, and the prosecutor first time is going to say this letter. So you have to look at the documents which they have, or the communications which they have addressed to the cops. Those documents cannot be accepted. And then the witnesses come that day. Prosecutor was feeling very comfortable that his job will be over, he will get the document exhibited. So maybe he is not even prepared himself to ask the contents or the facts mentioned in that document. And by your objection, you are getting away with it. So carrying these judgments and these objections at an appropriate time is very important. I wish clients start understanding this. Then comes the aspect on objections on exhibitions, which is one of the most important objections. Please be clear. In case you have not objected at the right time, save in exceptional cases where the document itself is being challenged. Your objections, you cannot take even at the time of it. You have to object immediately. If the document is a photocopy, scary. Dr. Morgan, very beautiful objected by Justice Makta, that a photocopy will not be accepted. And as I do these documentary evidences cases, generally these Prevention of Corruption Act and PMLA cases, or generally these cheating forgery cases. So, in such cases, a lot of such documents are given, like bank statements would come. Immediately you have to say, Malad, hit by Bankers Book of Evidence Act. At times they are giving electronic copy of a bank statement. Then your objection is also 65B Evidence Act, that it is not with a requisite certificate. Then your objection is also Bankers Book of Evidence Act. There has to be a certificate. Please read Bankers Book of Evidence Act carefully. Otherwise, what they would say is they will have a round stamp of the bank, say certified as per Bankers Book of Evidence Act. No, the content of those certifications are required to be proved. In 2G scam case, I kept on doing such objections. Later on, at the fag end of the trial, the prosecution realized that these objections might create a problem. That time at the fag end, they filed an application for proving somehow those documents or some other documents they wanted to file, and then we argued that this application cannot be allowed this fag end stage, otherwise it is like whole trial is going to restart, because they wanted to bring more documents, more now Banker Book of Evidence Act certificate or the 65B certificate they obtained further, the prosecution wanted to file, and then we objected, and then they were not taken on record. And rather, I got their admission of the prosecution in that application, where they had said that yes, these objections are there, these objections are valid, my lord, so permit us to bring the certificates at the fag end of the trial. So these objections you are to make immediately. Remember, regarding document, the basic objections can be these three: about the admissibility of the document, about the in civil, at times the objections are also made that the document is not properly stamped, so the document should be impounded rather. Though that objection cannot be made in criminal, in civil only that objection is made. And I'm not a civil lawyer, so I'm not trying my hand, but just it struck me, so I said it. I don't have CPC in my office. So, in criminal law, the objections generally are photocopy, Banker's Book of Evidence, or this 65B electronic evidence, this PV inverse judgment. So these objections you have to raise, and please, this Banker's Book of Evidence Act certificate language is important. 65B certification is language, again, is important. It is not as if that they bring a certificate, that I am giving a certificate under section 65B Evidence Act. No. Then you have to say that, my lord, please record my objection that this certificate is not in accordance with law. And we'll do it in some other session. Don't worry that it is giving a prosecution a chance to correct itself. Don't worry about that. So, we see that on so many aspects, you can fox the witness who is standing, who thought that you are not going to perform today. You can fox the prosecutor and earn some respect in the eyes of the court. That basically, when you are doing these objections, my favorite is this Jahira Sheikh, which says that the court is not a mute spectator or a recording machine or an umpire to see that who one is playing better. With these objections should basically be falling from the court. Basically, you are assisting the court in performing its judicial function, so any judge is going to appreciate you if you are making these objections. So, in the prosecutor, you will be standing out like a sore thumb, and that's your job as a defense counsel. I can give you one example. In previous scam case, though I will not name, there was a lady witness. The case of the prosecution was that a lot of investments have been made in a company of which she is a major shareholder, and she does not know anything about it. So that is why the documentation of this investment or this funds movement that has been done in the company is shared. If I was not present when the chief was recorded, I would not know. When the chief was being recorded, I was present. In 2G, I have been present at the time of the complete examination in chief. So I could see that the witness is unwell. Witness is not in that much senses. So the prosecution, I thought that the prosecution will not be able to get anything out of this witness, but the prosecution played very smart. It was asked from the witness that, do you know about transaction A? Do you know about this document? Do you know how these funds are moved? Do you know this? Do you know that? And to every question, the witness replied no. Even though I thought that will not do anything against this witness, will not even cross-examine. So, seeing this body language of the witness, because I was present at the time of the chief, I realized that whatever question is asked from the witness, she is going to say no. Her standard answer is, I don't know. So the prosecution is showing that despite being a majority shareholder, she is not aware of this transaction. That is why this transaction is sham. So immediately you have to be smart on your feet. So despite my plan was not to ask any question in the cross-examination, because I thought that they'll not be able to get anything in chief. So immediately then I asked the question from the witness, do you know what is my role? I pointed out at the prosecutor, do you know who he is? I pointed out towards the judge, do you know who he is? I pointed out towards the IO, do you know who he is? Do you know what is a Companies Act? Do you know what is a CBI? Do you know what is a charge sheet? Do you know what is being done today? Witness replied, I don't. So the whole game that prosecution had played was not to their benefit. In the cases which are based on documentary evidence, you have to get the objection recorded about the photocopy. Then there is one or other admissibilities. Then there is one very important objection, which is about that the witness is not the author of the document. Witness cannot exhibit that document. In a negotiable instruments act case, even though the evidence is recorded in the affidavit, when the witness is tendering the affidavit, object, that, my lord, he is exhibiting the notice. Notice is sent by the lawyer. So, the complainant, the payee, is not the author of the document. So, this document cannot be exhibited. At times in these Prevention of Corruption Act cases, whole file is being exhibited. So, make an objection. The court may also record that this exhibition is being done only for the purpose of identification. At times, the prosecution is in the habit of getting so many documents exhibited collectively. Suppose a witness has furnished 10 documents. PP Saab would come and say that you wrote this complaint letter, or this Caesar memo was prepared, and you gave these documents, page 1 to 126, collectively exhibited. You have to say, no, sir, stop. Document number 1, document number 2 is not the author. Document number 3, of course, by Kaliram, hit by Kaliram. So, document number 4, bank statement. So, Banker's Book of Evidence Act. Document number 5, my lord, electronic record. So, dear, you can really upset the apple cart of the prosecution. But regarding these documents, there is one more very big issue. That issue is that suppose you have objected to the exhibition of the document, whether that objection is to be decided forthwith or that decision is to be postponed. The moment you will request the court, the prosecution and most of the time court itself would say, oh, what are you saying, Mr. Kamsa? Bipin Shanti Lal Panchal. This objection would be decided at the fag and at the end of the trial after the final argument. You have to tell the court that, my lord, when you will record my 313, you will put the question to me regarding this document. That this is the document exhibited by the prosecution, what do you have to say? And you have not even decided that this document is in evidence against me. You are going to ask me, this document is in evidence against you, Mr. Accused. What do you have to say? And when you have not decided that whether it is an evidence against me or not, how can you ask me this question? Friends, you can even move an application. Suppose you come later. In a 138 case, the exhibition has been done, the affidavit has already been tendered. You can move an application to the court for even de-exhibiting the document. You must insist that my objection should be decided forthwith. That is written even in our Delhi High Court rules, that if an objection is done is by the defense regarding exhibition of a document, the court has to endeavor to decide it forthwith. But we will face a lot of resistance, rather not from the prosecution side, from the court side. But then you have to be ready with a lot of law in this. This is a too technical aspect, which can take one full session, but which is again very, very important. So this session will be done by my colleague Vijay Aggarwal, and I'll be requesting him to do it as early as possible. And now there are various orders from various courts where they have said that document exhibited on the application of a defense is now being allowed to be de-exhibited. So be there not just to bet. Don't just read books or the sessions on the cross-examination. If you are performing your role at the time of the recording of examination in chief and the other side scores poor, then you are not required to bet at all. So your 80% of the job is done. Thank you.